it's not allowed. We are also aware that the manner in which this is applied is consistent with the interpretation given by the Director General, that it is a suspensive condition, meaning that South Africa would offer an applicant a successful answer to an application for naturalization subject to renouncing citizenship with another country. So it doesn't happen before, it does happen after. So we are in agreement with the interpretation by the Director General. Thank you.
Okay, it looks like Honorable Kekana is happy about that explanation. Honorable Sope.
Yes, Chair, just the clarity on the explanation on the renunciation of citizenship. So when exactly? Before you apply, you must announce, as the DG was making an example of applying from other departments as the DG, or after we've been granted. So can we just get a clarity when this issue comes in?
It's just a little bit difficult. It is now the DG that must answer that one. It's the DG. Yes, the DG
you know, it's simple. That's why I was saying this thing. As long as you understand the process, that's why I was making an example like a job when you apply for a job. That thing has got. You get a short list. You go to an interview. You go to all those steps, and then lastly, when now we are giving you a letter of appointment, it's because you have satisfied all the conditions. Let me come to this one. You apply to say I've finished my 5 years. Your first requirement, I must have my 5 years permanent residence, and whatever you submit, then that thing is looked at it. After he has looked at it, I'm going to explain now when I come to the processing of civics. There is a panel which looks at that. Then after that thing of yours has been approved, then now if you are from a country which needs a dual citizenship, they write a letter to you and say, now we've considered your application has been approved on condition that you submit this. Then before we go to the system now and capture you as a South African, all those conditions must be met. Then now we have submitted your renunciation, then I can issue now with the ID number of South Africa. Thanks, Chair.
Do you still need the lawyers to speak to it, or it's clear? Thank you very much. Yes. Now we are being empowered. The DG proceed.
What is the process now of how to deal with these things? Because there is a process which we set so that we make sure that everything goes through that. The first thing which we do is that it is important to know that the initial processing of assessment, that's why I'm saying, Chair, on that bureaucracy we're talking about, does not sit in a minister in a corner and just approve these things. It is important to know that the initial process of assessment involves preparation of a submission by an official. There is an official who must get this thing, which when I deal with it, I will show what this is the submission which they prepare themselves to look at what is the criteria, what is this. Who goes through the file and collates all information in the submission to be presented to the Naturalization Adjudication Committee. Chair, why did we have a committee? Not a one-man or lady person sit and just make a decision. You need a panel so that you make sure that this thing is looked by a committee, not by an individual. Because granting someone a citizenship is not a child's play. Then that committee is chaired now by the chief director, who is next to me now, and then if he's not there, somebody else chairs it, and then it's got 3 members. The committee, now, what is the role of the committee, Chair? Which when we deal now with that issue, which we're going to come to it, the letter of my minister and overruling somebody else. The committee ensures that the applicant complies with all the requirements in terms of its role. Committee either approves or rejects. So it means the approval of that is with the committee, is delegated to the committee. It's not delegated to the minister, it's with the committee. And it can reject the same committee. So it means if your application is successful at a committee level, it gets implemented. If it is not, it gets rejected. The committee has got the power to reject. Then we're going to come to say now, what are the provision of 5B now? But I'm just giving the explanation. An applicant will now submit, an applicant will submit an application as an individual, as what I've already explained, even what form they do. And then now the Directorate Citizenship verifies the authenticity of the issued permanent resident. Is this certificate issued by the department or not? If the naturalization and adjudication approve the process of issuance, the applicant must then, with that process, must then sign declaration of allegiance, where the applicant's country, do you see now where it comes, does not now allow dual citizenship. The applicant must submit the renunciation certificate letter from the country of origin. It's the process, that sequencing I was talking about. Submission of above stated document will lead to the changing of identity number from permanent resident identity number, which provides for all rights, including the right to vote. Failure to submit a signed declaration of allegiance or renunciation letter will lead to the naturalization certificate not being issued. So you can comply with all this, but if you don't meet the conditions, that certificate won't be issued. Okay. Chair, I think now I've explained now the process within what is the law, what is this. Come now to the individuals which were listed in the letter. So,
second, honorable members, are we happy about the process? It has been claimed, it has been explained clearly, just on a theoretical basis, without attaching names, just the process as outlined. Honorable Stianese?
If I could just get clarity from Mr. Apleni, if I may. So that committee that sits would be the committee that would consistently sit on these types of matters. It's a permanent committee. And they would then be able to adjudicate their decisions based on previous decisions that they've made in similar circumstances. So it would, I would imagine, remove the arbitrariness out of the situation, because the people sitting on that committee would have had the experience of rejecting applications before and approving applications before. So that is the check and guard for consistency in your department. Is that correct?
Exactly, that's what we do. So that we make sure that that committee is appointed. We don't appoint a committee for a particular application and then appoint another committee for another application. That committee is appointed to deal with these things, and they're able now to maintain those issues of consistency and the application of the law. Okay. Then, Chair, let's go again now to the individuals now. So I give now chronological step followed by the applicants on each one. What did we do and all that? Let's start now. Mrs. Anguri Gupta. The applicant applied for and was granted a visa, then called temporal resident, dated 28 December 1995. It means this person arrived in this country just 1 year after the dawn of democracy in this country. So was here in 1995 with a temporal residence permit. So that when we deal with this fast tracking and all that, we understand it, that this person arrived in this country in 1995. And then again was issued with another one in 1997. That's why I said this means that she arrived in the country in 1995. Further, I applied for another one for reunion with the family in 2001. Then, according to our records, we have looked at it. She has been here for about 6 months' time during those periods. Then, Mrs. Gupta applied for a permanent residence permit, which was approved in 10th March 2003. Chair, permanent residence. 8 years after her first TRP granted in 1995. So it means this person, as from 2003, had all the rights in South Africa except the right to vote. Is that clear, Chair? Okay. Then, thereafter, Mrs. Gupta applied for naturalization now on June 2013. I said as part of the family, which was 10 years since she was granted, we say temporal, since she was granted a permanent residence permit as against a requirement of 5 years. So when Mrs. Gupta was applying for naturalization, if you can add all these years, I mean, the other one I said, what was 8? Other one was 8, and then the other one was 10. So it was 18 years, this person in this country. And Chair, I said, when I was opening, I respect the citizens of this country. I respect people who are in these shores of this country, because I couldn't discriminate in 1995 and says, no, you cannot come here or for whatever. I don't have reasons to do so. Unless there's information which says we are not a good character. Okay? Then let's read again now based on what you said. This committee, her application was rejected by the Adjudication Committee on 23rd December 2014. Let's go there again now, Chair. Annexure C. Is that bureaucracy I was talking about to you. And you see now this thing is rejected by the committee. Now, here is a submission, is on C to CC. It says now, to obtain, is a committee. Now, remember, in fact, Hlachwayo is the one who signed this document. Hlachwayo is the one who wrote that letter, which was in circulation. So she was a secretary. It's a female. It's a miss. Yeah, she is a secretary committee. Now, if they give background, her permanent resident was issued word, it was verified. Number 4, Chair, 2.4, the police report shows that there is no illicit activity identified. There is no adverse information on the applicant's police clearance certificate. Chair, what is important, Gena, is this thing below. Period of residence. Chair, it means, remember I said 5 years preceding. It means now this person on year 1, year 2, year 3, year 4, she did not go out of the country. You see, check the zeros. But now in the year 2013 to 14, she was out of the country 3 months and 18 days. So it means she exceeded the 90 days by 18 days. What made this person not to meet the requirement is because in the last year, in the last 5 years preceding her application, has got a 1 year where she was out 3 months and 18 days. That made her not to qualify. That's why, again, if you go to the next page, the committee did not approve this application. And the reason why they did not approve this application is because this person did not comply. They put what is the regulatory policy or regulatory compliance. If you go to bullet B, it says, as a regulatory requirement, any person who lodges an application should not have been absent from the Republic for a period of more than 90 days in any year during the 5-year period of ordinary residence immediately preceding the date of application of naturalization. In view of the fact that Mrs. Gupta does not comply with the requirements, refusal is recommended. It's the committee. Let's move. What did we do? Hlatshwayo, as a secretariat, writes a letter to the family. One of the things, if you go to paragraph 2 and paragraph 3, it explains to them clearly what made her not to qualify. It's because they don't meet that requirement. Then the last paragraph, which Chair, I saw that letter which was circulating. That letter has been, what is the right word now? No, it's been tampered with. Yes, that letter said, however, you and your family will qualify to reapply on 23rd December 2017. That letter says 2015. It's wrong. It is 2017, and I will explain why it was 2017 and not 2015. So that's the first thing which is wrong in that letter, but we're not discussing it now, but I'm just highlighting it. Okay, then Chair, let's go to the next person now.
Yeah, shouldn't he just deal with the
All the
five
names?
And then because of whatever you may raise, maybe it is also applicable to the other persons. Let's just complete that bunch of the names of the 5 names, and then we will subject it for clarity.
Let's come now to the 2 applicants, again part of the family. AJ Gupta and Shivan Gupta. Shivan Gupta is the wife, and AJ is the husband, and AJ is the son. Come again? Annexure E. Annexure E. Okay, it's the same from there, but what is important is the period of residence, 2.61. If you look at 2.61, husband, Mr. A.J. Gupta has been in the country, did not exceed any period. In the 2013 to 24, it was 1 month, 18 days. In another year, it was 2 months to 5 days, 1 month, 2 months, 10 days. So in terms of that, he has not been out of the country to make him not to qualify. Had he applied as an individual, he would have got that without anything because he complied with the regulation. But he applied as part of the family. That's why he made him not to qualify.
Honorable Melder, I will still request that we hold on so that all the names, then we have them. Just try and make note that we just go through the names and their circumstances in relation to this application. Then we'll subject it to your inquiry.
Then now on number 2.6, the wife. The wife did not have the 5 years. Was short of the 2 years in this. Then that's why our application requires applicants to apply as a family. If one of family does not qualify, it affects the rest of the family. That's why they were putting that there. And then now you come to the next thing. It says now, in view of the fact that does not comply, refusal is recommended. They write whatever the committee. Then now we go to the sons. The sons, Chair, because we were worried about that, this thing of a surname might be an issue, is Kamal Kant Shingala. So we said people are going to say, hey, these are not Guptas. That's why we attached the letter, where in terms of the culture in India, a child they name it as Shingala, but it's the same thing as Gupta. So these are the sons, but they are following a surname. If you look at these ones, this one, they are, firstly, what is important, they are more than 18 years at the time of application. So the youngest, who is Surya, who was born in 1995, by the time now he was applying, he was already 18 years. So he was above the years. And if you look at them in those dates, they arrived in Abapongo 1995. I think that one arrived here as a child, really. He arrived in 1995. So if you look at them, their period of absence was less than if you look at the schedule. And then, Chair, it means now they were qualifying. You will see now if you read, in view of the fact that Kingala, though it says does, it's supposed to say does comply with the requirements of section, the approval of his application is recommended to him. But because they were a group, then now all of them, they did not qualify. It's the same with the next son. They did not qualify. Now, Chair, once that now has happened, the committee has declined these applications. Now, what is the rights of these people, not them, anyone? Then that section 59A starts now to kick in, to say, we have failed the application because we do not qualify with that 51C. Now, what can we do? It's within their right. It's in the law. Then now you can approach the minister with your exceptional circumstances. Then, before I get to what the letter, let me deal, Chair, with this thing, because when we get into it, the letter of Hlachwayo and the letter of the minister. Chair, this country, this one, has got a hierarchy of the courts. You go to a court A, which I've done in a lot of cases. I go to the Court of Appeal. You lose a case there. Then it goes to the Supreme Court of Appeal. It reverses the decision which was taken by the lower court. Because it's the hierarchy of how things happen in our country. But what you cannot do is that now I'm at a lower court, I change the decision of the higher court. That's why they will call that as a contempt of court. You can't do that. So, Hlachwayo, letter they are writing is within their own right, is what they are delegated with. They've applied the law right, and they were able to say, these people as a family, they do not qualify. And whether one or one qualifies, but they dealt with that. Now, what happened now? Comes again now to this bureaucracy I was explaining. Go again now, Chair, to Annexure J. No, in fact, we can go to Annexure I. Annexure I, they exercise their right to say, in terms of that section, we believe that we're in exceptional circumstances, which can now, as we're discussing now with Honorable Oosthuizen, it will depend now whether now to you or to me or to anybody else are those reasons carry a weight. But on that thing which you were saying, I'm going to be giving you others who have dealt with it and check whether when I compare this and compare that, it means that there was something irrational here, which can, if that is the case. But I'm not going to read the letter because it was already there. It says now they've got investment in the country and all that. They've employed 7,000 employees. They've got whatever. They've invested about 25 million. But, Chair, let me correct something here. Another assumption which can be made. There is an assumption which now says we must believe that the money which is invested by the Guptas can only come from AJ. Chair, I don't know. the family, the first person who came here is the mother. And I'll be wrong if I can think that if I am rich, my richness can only come from me as the son. I can inherit something from my mother. So why now we believe that if the letter is saying this is the investment which we have, it is equal to, that is the son who's got that money? Secondly, it's a wrong assumption again. If now I believe that my wife can only be poor, it can't bring anything to me. If now I applied with my wife on this, the person who's got the money here is me. It might not. So what I'm trying to explain here, Chair, in this thing is to say that business is of that family. I don't sit and say, tell me about this one contributed 10%, this one contributed 5%, this one didn't contribute anything. That's why, Chair, in the letter we explain, where do I get that? We go to DTI, but I wasn't going to touch those things here. DTI confirms what this business is registered. We go to SARS. SARS confirms that this business is registered here, is paying tax. So what else must we do? But what I'm saying, let's correct this assumption that if now there is AJ, there is mother, there is a wife, the only person amongst the three who would have contributed here, it means it's AJ. It's an incorrect assumption. Let's continue, Chair. I'm talking about our bureaucracy now, coming to that question. Here, Annexure J, how do we do this? We said first, we start with the committee. Committee has done what they are doing. In a bureaucracy, Chair, no minister would just sit and write a letter. A minister is advised by his or her lieutenants, which in this case, the last one is the DG. If in the line we have applied the principle wrong, yes, the minister is taking the ultimate responsibility. But the steps below, they are also not clean. You can't say, no, I recall I was passing it up. I've got a responsibility as each level that this thing is not complying, this thing is wrong, this thing is like this, and then based on that. However, the minister ultimately, he must look at it and say, I have satisfied myself, everything is okay here, then I can do it. Let's go again now to this thing. It says now the purpose to submit for ministers' consideration. Annexure J. Or maybe let me be J by, I want to go to the J number, J by 5. 1, 2, 3, 4, 5, 6. If you can open that, but I want to start from the back. If you go to the J about 5, you know, the person who prepared this document is Mr. Skakana, is here, is sitting here. No? Then from Mr. Skakana, it came to Mr. Ramashia, who is sitting here next to me. Then from there, it went to Mkiza, the DDG, who is not here today, but we know him. Then from there, it came to me. And then from there, it goes to the minister. So if now these people who are here on the line have not advised the minister properly as bureaucrats, they did not understand what these laws means, then is a problem. But I'm not saying the minister is the final approver. Must simply say I've been advised. But Chair, he does not sit in a corner and write a letter. What is important here, Chair? 6.2 on that last JJ, a draft reply to Mr. Gupta is enclosed for minister's signature, please. Should minister concur with the contents, therefore? So it says now that we are recommending minister must apply his mind And then now, based on that, look whether the law is complying with everything. So that's what, as bureaucrats, we did. But Chair, what is important with this submission, I want us to go now on the JJ. Yeah, or J by 2. Yes. You see, if you go to 2.3, it says now the applications were adjudicated on 23rd December 2014 and were rejected due to the fact that Mrs. S. Gupta, wife, and Mrs. A. Gupta, mother, did not meet the residential requirements. It's not all of them. That's why we're explaining, Chair, to say the other 3 met the requirement. However, because as a family did not meet the requirement, that's why we are mentioning it to the minister, so that he mustn't sit and say, all this group did not meet the requirement. But it's only 2, but the motivation is for the whole family. That's why Chair was coming to that issue to say, it mustn't say, no, because it's Mrs. Gupta and Mrs. A. Gupta, those letter of motivation can't fit to them because I've already judged them and say the one who brings richness to that family is this person and that person and not the other. Then Chair, it goes and say, which I'm saying 2.4, it raises to say Mr. Gupta and the 2 children did qualify. Their application were rejected as per regulatory requirement under Section 3.4 of the Act, which stipulates that all members of the family, it says now including the applicant, must qualify to be issued with a naturalization certificate. According to the calculation, they will qualify for naturalization on 23rd December 2017. It's the same with the letter which is written by Hlajwayo to the family and say, you will qualify in 2017. And then it goes again now subsequently to the refusal. We received their motive in terms of what business do they have, and we quoted. Then now number 2.7 is what is important. The document submitted from South African Revenue Services shows that Oak Bay Investment is registered with them according to the information certificate. So, Chair, we verify those information. We don't just sit and get a letter and then thereafter we say what we have written, it means what it means. And then there's a DTI as well. I don't know where that, but I remember it's somewhere. Where did I put that one? I don't know where it is. But we also got in the documents, there's also, no, it's here. The documents submitted intellectual companies and all that. We also look at that the certificate, according to the information on the certificate issued by companies and Intellectual Property Commission 23rd, shows that Oak Bay Limited is registered. What are the active directors? Then Chair, in the policy framework, which is now 4.1, when this document comes to us, what is 59A, which will tell Minister what it is, then the recommendations now. It is therefore recommended that Minister consider granting Mr. Gupta and family certificate of naturalization in terms of this, as we quoted all those things which are in that act. Then based on that, that is the letter now, which is on K. That letter which is quoted in that submission was not even drafted by the minister. It's drafted by the officials. And now they explain now to them again about that. They have done that. Minister, in powers vested on her, decided to waive this. The issue now, Chair, is that if we've got a scale, I might have put those things in a scale, they carried a weight. Maybe to you, I put it on a scale, it doesn't carry a weight. But the decision maker applied his or her mind. In this case, the minister or the people in the group of the list, we applied our mind. And we looked at that and say it suffices. Now, let's come again now to that question which was asked. At what point do you renounce? Go to letter L. It says now, dear sir, declaration of renunciation of Indian citizenship, yourself and the family. You are hereby informed that your application for South African citizenship has been conditionally approved. It's not saying has been approved. It's conditionally approved. Eh? No, it's L. What's it then? Oh, I can't see the date again now. Yeah. No, but yeah, no, but the letter surely is written after that. Yeah, yeah. Okay, no, it's fine. No, let's continue. Yes, yeah. But there's a where's the date stamp? We must check whether it doesn't have a date. Maybe it's a copy. So maybe in the date stamp we'll see it. Okay. You are informed that your application for South Africa has been conditionally approved. You are kindly requested to submit the following in order to finalize the issuance of, but there's even a reference number, that the issuing of the citizenship certificate, proof of renunciation of your Indian citizenship. On receipt of these documents, you will be required to sign the declaration of allegiance, which we're talking about, after your South African citizenship will be finalized. This assurance of citizenship is valid for 6 months from the date of issue of this letter. So it means if they don't come back within that period of 6 months, then that process again will start again. Now, we go again now to, is what we were asking. Here is the people now who submit to us. What is there? So this is a Consulate General of India. They put what is their reference number there, 4763-2015. They've got a date, at least get them. And then they put what they are saying. And then that is for Mrs. Gupta. And then the other one is of the wife. The other one is of the son. The other one is of the son. And they quote their passport numbers and everything. Now, based on these things, now it means now Mr. Gupta has never renounced his naturalization. So Mr. A. Gupta is not been naturalized. Has not. Is still a permanent residence holder. The people have been naturalized is this four. That's where now the certificate of naturalization can be issued. Then I'm coming to that question again now, which was asked, another step. If now we go to implementation of naturalization, Chair, then I want to go to point number 32, because that's where we are, which is a question which was asked by the honorable member. We are saying here, Chair, in terms of Section 59B of the Citizenship Act, the department is required to table names of those granted SA citizenship by naturalization to Parliament. We're saying that. What is the point? We're saying, the last report was submitted in 2012. I'm going to go through it. Annexure R. Since 2013, the department naturalized whatever. What is important is the point. It was an omission. That's what we're saying. We're saying we did not table that. But what we're going to look at, was it only Gupta family at the Minister Gigaba's time only, when the department did not do that? That's what we're going to try. Let's go to S. No, R. We touch R. We are saying in R, on 16 January 2012, the Minister of Home Affairs tabled this. And then number 2, the Minister of Home Affairs, a list of approved early naturalization applications for 2010 and 2011, terms of 5/9. And then from there, you go to the list. It gives the list of people who in 2010 were naturalized and give the list of people who were naturalized in 2011. So, Chair, that rule says you must table that within 14 days in the opening of Parliament. If you look at this, it means now the 2011 ones were correct, but the 2010 were incorrect. They were tabled late. But maybe that's why we'll deal maybe with legal to say the requirement is for tabling. It doesn't say, Chair, there is a condition that the Parliament must look at that and then says we are happy, therefore proceed. It's not a condition to grant the citizenship. It's the requirement that we table. That's why you are saying, for not tabling, it's not correct. That's what we're saying. We should have tabled this, but by not tabling, it can't be equal to they are null and void. But let's go get to the list so that now we see when we said we last tabled in 2012. The first person on the list, which now were not tabled, is Mr. Jerome Walter Henry Falfelke. This person, Chair, was a Secretary General of FIFA. No, Annexa S. No, I'm taking you through. That's why I'm waiting for you. I'm not rushing. So the next one is a sports skills soccer. We remember we wanted to understand what those people are. This one, Mohammed, it owns a business. So Gupta family who applied to us, they own business. It's been done in 2012. And then after that, we approved Prevost James Castle was a marketing director. We approved Agula Vasco de Jesus Paradas is owning business. And then we approved Allah Black Ali. We've even put their nationality, own business. Dino Gabrielier was approved, a pastor. Then the family of Gupta is here. Chair, I'm going to come back now on this issue and then the people who are here are only those because he is not here. Mr. J is only the 4, which is the mother, the wife, and the son. And then Chada family, and Adenji family, Kalumbu family, and Duyan Kim and Welso Tamas. So, Chair, what this thing now means is that the previous ministers of Home Affairs, we have not tabled the approved naturalization from 2013, but it's for that list. That's what we'll be having to correct. But Chair, if you go to Annexure T, in particular again now with the Gupta family, why we use this? We received a parliamentary question from the Honorable Member Hussein in April of 2016. And he asked us, whether his department issued citizenship to any members of certain family. And then, no, that one is not, I'm going to deal with the next one. We gave the names. They are there on that, but no, you don't have that one, Chair. It's going to be the second one. I got this one, but it was April, this one, 2016. Oh, okay. So what I'm saying here, Chair, is that by even responding on that question in April 2016, we're not hiding anything. It was there, we reported it. Then in October 2016 is the one I attached, number T. Again, Mr. Hussein asked the question. And then if you go to T, 1, 2, 3, 4, 5, based on, we even said with reference to his reply of question 1007 of 25th April 2016, what are the full details? Then we replied, what shall we said here in 2016 when we're recommending to Honorable Hussein is the same with what is in these documents. The reasons did not change, we explain it. So, Chairperson, there's nothing on this which we did not report. So, the issue now which we're saying is that we did not table that on that date, and when we did not table, I'm still saying, Chair, that's why I was saying it was not a right thing that we did not table, but we did not table only the 5 names, but the 5 names which were not tabled, we reported them in Parliament are there. And we gave the reasons, we gave the names. Chair, I think at that point again now, Chair, we are ready again now with my team to be able now to take questions of, and Chair, whatever, we'll be able to try and respond as a team. If there can be something we don't have, we will submit back to the committee if there's something we do not have.
Okay. No, thank you very much, DG. And honorable members, I think now we may be better off than before we started this meeting. And we should be able, we have got the tools now to actually talk to the things that have happened. And there is a declaration that, yes, it is not right not to table, which is being accepted, and with the intention to correct that. And then again is that it is not the Gupta family only that were not tabled, and it is not also related to one minister, it's a couple of ministers for the department that had that particular situation. We are having that. And then I think also the serious issue that needs to be, that we need not to miss, it is the workings of the department, as described by the DG as the bureaucracy. And then I think we have been taken on the process and how the documentation then started wherever they started until when the minister had just to exercise at the end to say I agree and sign, I don't agree and sign. And then we have been taken right through that. That's why I'm saying is that I'm sure even our brothers and sisters, fathers and mothers and uncles and whoever that is actually